Ladies and gentlemen, boys and girls, hello, namaskar and welcome to LawCharcha. Today we have with us Hasit Seth, my very good friend and very experienced counsel in Bombay. Primarily his expertise is arbitration amongst other commercial litigation. He has a vast experience not only in India but also abroad. He has completed his LLM from US in intellectual property rights. He has also completed LLM in constitutional law and commercial law. He was gold medalist in constitutional and commercial law in LLM. So it is indeed honor and privilege for us to hear from him regarding arbitration. We will begin with the concept of arbitration. What is arbitration? How is it different from other litigation? That is what we will get to know from Hasit sir.
Thank you, Rishikesh, for inviting me on your channel LawCharcha. And arbitration is a topic in which I have developed some interest over the number of years. And coming from a civil litigation background, this was a very new area at a point when I started taking interest in it. I started practice in 1998. The Act has come out in 1996. And the background of it is ancestral model law and rules and all that. So India was an early adopter of the ancestral model of having arbitration as a system. I must tell you that arbitration is not unknown to India. Even before this, there was the 1940 Act, the Arbitration Act of 1940. And that time, the domestic law was separate and the foreign law, the law for enforcement of the foreign awards was separate. So, and even before that, there was some statute. Don't want to get into that. But even like the earliest cases here in India also have involved some kind of arbitration. If you look at the earliest Bombay cases, some of the other arbitration exists. Plus, apart from this, the merchant associations, the traders, particularly Bombay as a trading center, always had some kind of combined mechanism of arbitration and conciliation. So they would call it a Mahajan, and they would sit across and solve trading disputes between two traders. So now also it exists in many different associations. So for example, there is a Cotton Association of India. So their differences in disputes between cotton traders go there. There is a Clothing Manufacturers Association of India which has its own arbitration rules and mechanism. So the roots of arbitration are into the mercantile system, that people in business essentially wanted quick and easy way to resolve mercantile disputes which have very similar patterns. That I sold goods, didn't get them, or the quality was not good, and all that. So why go to civil courts for that purpose? And civil courts have always recognized, settlement between the parties, even before the courts or after the courts. When you come in litigation and settle, courts have always recognized settlement. That if you have your own mechanism to settle your disputes, we don't have a problem. And they'll recognize that settlement and even include it in the compromise decree. So civility. So the idea is not that civil litigation system is something different from arbitration. Both of these systems have coexisted since the longest possible time.
Okay. But just that because the traders want a speedier redressal to their issues, that is the reason why they adopt for arbitration. So basically, let's understand from you how many parties can arbitrate at a time, or what is the nature of dispute that can be that is arbitrable.
Correct. So the arbitrability as a concept and a challenge, have the disputes about it still continue. Recent judgment, relatively recent judgment like Vidya, etc. Arbitrability has been disputed all along. Because arbitration is an act which has come on top of the other Civil Disputes Act. So within civil system also, if you see when the Consumer Act came, There are lots of disputes whether this would be a consumer dispute or this would be a regular civil suit. Because let's say you bought a fridge or a TV, right? I mean refrigerator or a TV, and it doesn't work. It could very well be a civil suit because it is under the Sale of Goods Act.
Correct.
I mean, so it should go to technically to a civil suit. But now you have a special overlaid act over it, which is the Consumer Courts Act. So it defines what is a consumer, what would be a consumer transaction, and what would go there. And it's essentially an extra remedy that has been created.
So is it that wherever there is a special enactment, it is not arbitrable, or whether it
Yes.
is?
So these are issues where the courts have taken a policy decision in a sense
Okay.
that certain disputes which concern either the status of the parties, very special status of the parties, or special subject matter of the dispute. Those the courts have said that let them be under the special machinery created under it. So Consumer Courts Act definitely is one. Consumer forums. I mean, as such, a special enactment. Same thing with Rent Act. So the Rent Act disputes, the courts have said that arbitration should not get into it. Otherwise, I would think the rent disputes, and across the world there are arbitration, mediation, conciliation schemes for rental disputes, because they are of a very stylized and a fixed kind of set of disputes. Well, you would have simply that rent is not being paid on time, my premises are damaged. So this would be apt disputes for arbitration, but as a policy choice, because there is a special statute and a special machinery under the new act, there is a rent controller for this legal license. It's even beyond judiciary, it's gone into executive domain. So that's why the courts have said that those you don't get into.
Yeah, and we see that even consumer enactment, though it is a special enactment and there is a special forum for it, still there are a lot of delays. Similar to civil courts. So ultimately, maybe in future policies will be reformed and more arbitration scope will be widened. I don't know about that.
So the big difference between this carve out over others is that Arbitration Act itself does not define arbitrability. I mean, broadly, disputes of civil nature, commercial nature, that's the zone around which it operates. But I mean, what happens is that disputes themselves, the distinction between arbitration and other systems, because all these other forums that we decided, other machinery or forums we decided, discussed, still they are created by the government. That's the big difference.
That's right.
In arbitration system, except for the passing act, the government has no role. Government role, and in a sense through the judicial role, comes in when it is there to review certain orders or what is the judgment of the arbitral forum is called an award. The word judgment is not used. It's called an award to distinguish it itself from the court system. So it has its own terminology also for this purpose. Setting aside of the award, it's called a setting aside procedure, challenge proceeding. Just recently I learned that there are two authors, Redfern and Hunter, they invented this word challenge when they wrote their first book, because to distinguish it from an appeal, that is not really an appeal.
Oh, really?
So
that's interesting.
So here it's a private mechanism. Rest of the stuff, formation of the tribunal, appointment may be done by the court under Section 11, but otherwise, rest of the whole mechanism is to be done privately, in private premises with, lawyers, the arbitrator also being, either an agreed upon person or one appointed by the court. You pay the arbitrator, and at one time arbitrator has only one case.
Actually, I will be coming to that about the appointment of arbitrator. But before that, I would also like to know, since you referred to terminology, there is some terminology as ad hoc arbitration and institutional arbitration.
Correct.
Can you throw light on that?
Yes. So, right from the appointment onwards, our law allows, institutional arbitration.
Okay.
So, ad hoc arbitration essentially means that there is nobody managing the arbitration. And the whole mechanism is such that essentially the arbitrator controls the process. And decides many steps that go along the way. So the administrative burden, when you are in a civil court, there is an administrative machinery supporting the judge. everybody from the bench clerk, the registry to the person to issue certified copies of the orders. There is a full machinery backing up the judge. There is no machinery here.
Acha.
The arbitrator does everything himself.
Okay.
So this is actually quite burdensome. But current, the norm is that, and there are various studies, etc., and people keep discussing numbers, that almost 80% of the arbitrations in India are ad hoc arbitrations.
Oh.
And rest are, say, institutional arbitration. So now the question comes of who creates these institutions. So these are, sui generis institutions created. Lot of them have been created by the chambers of commerces, because again going back to the mercantile roots of arbitration, that they think that we should have a chamber of commerce.
Sui generis as in created by them, a group of people.
Private arbitration association also. For example, not here in India, but JAMS in United States is a private arbitral organization.
Achha.
So it's just a private company and they are providing services. I mean, there are many of them. I mean, not just one. But usually they are structured as non-profit organizations. And so you have very famous ones like the Mumbai Center for International Arbitration. There is IAMC in Hyderabad. There is Delhi International Arbitration Center, which sits in the Delhi High Court's premises, but it is an arbitration center of its own, with its own act and rules and everything. I mean,
so domestic arbitrations also can be.
Yes, so these institutions administer. So what they do is known as administering of an arbitration.
Okay.
So they carry the responsibility of the administrative part of the arbitration, like collecting fees, like appointing the arbitrators, then distributing the awards, for example. There is also a case manager assigned with every arbitration. So there is a machinery, just like the judge has a backup machinery to support his work in the court. In the same way here the institutions performs that role. I mean, and they also have an educational and advocacy role where they go out and educate and advocate for institutional arbitration, so that they obviously charge a fee. So main thing in people's mind is that if we do ad hoc arbitration, then we only have to pay arbitrator's fee and not the institution's fee. So institutions do charge a fee, but I think it is worth the value of the money that they charge, because I'm not to say that this is that or better, but because I do both kind of arbitration as a counsel and arbitrator, but I find that overall the value they add is just like, imagine a judge sitting there with one desk and doing everything himself.
True.
How difficult it would be his job. So, papers also is managing, everything is managing. So I mean, so institutions bring a tremendous value. I mean, for whatever fee they charge, I think it is worth if you want a quick resolution of the dispute. And in businesses particularly, there is no desire to let the dispute linger on, because a lingering dispute is a liability for any business.
So, as in internal arbitrations would be providing a better support mechanism.
Yes.
For the end of the
conducting and process of the arbitration.
So that now we will come back one step.
Yes.
How an arbitrator is appointed.
Correct.
That will like to.
So the arbitrator, if you have a contract with an arbitration clause or a separate arbitration agreement, the interesting part about arbitration is that you can decide to go to arbitration even after your disputes have arisen.
Okay.
So your original contract may not have an arbitration clause.
अच्छा, तो कॉन्ट्रैक्ट में यानी ये बहुत इंपॉर्टेंट है, अगर कॉन्ट्रैक्ट में आपके आर्बिट्रेशन क्लॉज नहीं भी होगा तो भी
डिस्प्यूट होने के बाद में भी आप डिसाइड कर सकते हो कि कोर्ट नहीं जाना है, आर्बिट्रेशन जाना है.
Okay, so this is important aspect, that it is not necessary that there has to be a written contract.
Yes.
You can still decide to, if there is a dispute, you can still decide to go to arbitration.
So these are known as submission agreements, that we decide that these are our disputes, and we want to submit them to the arbitration.
Okay.
And then the courts will also recognize that submission agreement, that parties have decided even after the disputes have arisen that now we want to go to arbitration to resolve these disputes.
Now let's see, there is an arbitration clause.
Yes.
So अगर arbitration clause होगा,
हाँ,
तो फिर appointment यानी कैसे होता है?
So the appointments, two mechanisms. Parties themselves, once a notice of invocation of arbitration is signed, the other side can simply say yes, we agree to the arbitration, and both the parties together can decide who will be the arbitrator. So the courts need not be in picture.
ओके
सो डिसाइड कर सकते हैं कि ये पर्सन से हमको आर्बिट्रेशन करना है.
सो नोटिस का कुछ टाइम पीरियड है यानी
हाँ, so there is a time period that in 30 days the other side has to reply, respond that this is the
so this is all governed as per the
Arbitration Act में mechanisms दिया हुआ है.
Okay.
So if they don't respond like in the time frame, then the other side can go and ask the court to appoint an arbitrator.
Okay, so the court is given
Jurisdiction, and somehow it has become a culture here that whenever the person sending the notice proposes the name of the arbitrator, the other side rejects it because they think that if that
there is a bias.
There is a bias that if this person is recommending so and so person's name, so why should I accept it? But I think the better mechanism and opportunity for the judge, for the parties, is to actually sit down and decide on a name of a neutral person as an arbitrator instead of fighting over this name or that name. So if you agree on a very senior person to be, or a person you think is an expert in that area, so like if it's a construction dispute, let's say somebody is an experienced engineer and wants to do that, can be the person who can resolve the dispute, that you can take that person as an arbitrator, nominate that person as arbitrator, both sides can accept, and or both or more, as you said, like how many parties should be there, you had asked. Any number of parties can be there is no problem about that. Typically, one
just like
different you can have any number of plaintiffs, any number of you can have multiple disputes being submitted in the same arbitration, but there should be consent of all the parties. Arbitration is a creature of a contractual consent.
Right.
Arbitration does not arise from one party forcing other party to arbitration. So a lot of people say, "Check, हम इनको arbitration में drag नहीं कर सकते क्या? इनको arbitration में खींच के नहीं ला सकते क्या?" You cannot do it, or you have to have contract as the basis.
Right. So the agreement तो होना चाहिए.
Agreement तो होना चाहिए.
Okay. So and now there
are dispute की बात में होगा,
agreement होना चाहिए. अब मेरे ख्याल में और एक इसमें चीज होती है कि there can be more than one arbitrator also.
हाँ, हो सकता है.
So especially when you are referring to that expert, so there so that expert can be added into the panel, something like that.
वैसा भी हो सकता है. बट इसमें मैकेनिज्म इस तरह है कि ऑड नंबर ऑफ आर्बिट्रेटर्स होना चाहिए. इवन नंबर अपना एक्ट जो है वो इट डजंट एक्सेप्ट.
सो डिवीजन बेंच जैसा
डिवीजन बेंच नहीं चलता है. हुआ करते थे एक टाइम पे, बट अभी नहीं. अभी नहीं.
इवन कुड बी दैट देयर कांट बी एनी कंसेंसस.
हाँ, स्प्लिट अवर्स होते हैं. तो एक जन एक साइड से एक तरह से डिसाइड करेगा, उससे दूसरा जन डिफर करेगा. सो देन अगेन उसका रिजोल्यूशन नहीं हो पाएगा.
देयरफॉर थ्री
आर्बिट्रेटर्स. सो यहाँ पर भी डिवीजन बेंच में लाइक वी हैव कोर्ट्स मैकेनिज्म कि इफ दे डिफर देयर इज अ मैकेनिज्म टू अपॉइंट लाइक एन arbitrator, third person to either take this side or that side. I mean, so that's. But there is one other important aspect I want to mention is that arbitrator need not be a lawyer. This is a very critical thing to understand.
Okay.
Arbitrator का कोई legal background होना कोई जरूरी नहीं.
I will come to that. I will also like to cover you the procedures during the arbitration, because इसमें ये बहुत एक अहम बात है कि when you said that he need not be a lawyer. So what exactly procedure does arbitration adopt? It seems to be entirely different.
Correct. So correct. So just to complete this thing. So anybody can be appointed an arbitrator. That's why when we mentioned engineer can be an arbitrator. So the logical question कि अगर वो lawyer नहीं हो तो कैसे चलेगा? So ऐसा कुछ नहीं है. Anybody can be an arbitrator. Then like the appointment itself to compete. So if one person does not agree to certain person as an arbitrator, then the mechanism is under Section 11 to go to a court, and the court will appoint an arbitrator.
Okay.
And just to complete, if there are odd number of arbitrators, 3 arbitrators, and parties want to appoint them by consensual, the mechanism is a little different. The mechanism is that each side will appoint one of their nominee arbitrators, party appointed arbitrators, and both those arbitrators will then appoint a third person irrespective of the consent of the parties.
Okay, because essentially those parties have decided to give their power
to appoint arbitrators to the 3-member tribunal to those 2 members. Each side appoints one, and then those 2 appoint the third person. So the neutrality of arbitration tribunal is built up in this way that let each side appoint one arbitrator and let those two appoint a neutral person. So then there is no deadlock kind of usual that the general impression is that if we have nominated an arbitrator, he should be like advocating our side. But this is absolutely wrong. Once the party exercises the power to appoint one person as a nominated arbitrator in a 3-member panel, that is end of it. That arbitrator has no duty to explain your position, advocate your position at all.
Okay.
So he is a neutral arbitrator. Only the nominating power is given to you under this mechanism. So here also, whether a single arbitrator or 3 arbitrators, if it goes to court and the court has to appoint, then court may ask you to suggest 2 people and appoint the 3rd person, or court may appoint all 3 arbitrators also if you are not agreeing to anything.
Okay.
Or if it is a single arbitrator agreement, but the court will respect the arbitration agreement. If it is a 1-person mechanism, court will appoint only 1 person. If a 3-member tribunal, court will only appoint. So the party's consent in the original arbitration has to be respected by the court also.
So I suppose it is very clear now, the appointment procedure and how multiple arbitrators can be appointed and what is the basis behind it.
Yes.
Now let's also understand, when I talk about the procedure of arbitration, how is it different from the normal civil courts? Because I suppose there is no strict norm that you have to follow a particular procedure as per CPC.
Yes. So that's the big advantage of arbitration. That whole of the procedural part of it, which means the civil procedure and the evidentiary part of it, is extremely flexible. Extremely flexible in the sense that the arbitrator, the first right is given to the parties to design a procedure according to their convenience. Then they can adopt whatever procedure they want until it doesn't violate the basic norms of fairness, and gives both sides equal. There is a section which says both sides should be given equal treatment by the arbitral tribunal. Unless it does not violate that, you can have any mechanism built into it. And this is quite shocking to most people who are into civil litigation or ordinary public also. कि इस तरह का मैकेनिज्म किस तरह से आ सकता है?
जैसे हम देखते हैं कि यानी फ्रेमिंग ऑफ इश्यूज, ये एक सिंपल स्टेप है जिसको काफी वक्त लगता है सिविल कोर्ट्स में सिर्फ इश्यूज फ्रेम करने.
Correct.
So can in arbitration that step can be done away with, or
अगर parties decide करते issues frame नहीं करना है तो it can be waived.
Yeah, because ultimately parties to the arbitration would be knowing what they are expected
so they can actually, so a lot of things start with submission of the issues. While it is not a mechanism in our system, but in the UNCITRAL model which we have adopted, if in the notice that you send to invoke the arbitration, if it has given all the grounds that are there, and if in the reply to that notice, all the responses are given, you can adopt that as pleadings.
Wow, so that is really, in civil litigation,
it would be impossible.
Yeah, it is. There are so many pleadings.
Yes.
There is rejoinder, sur-rejoinder,
correct.
piling up. And if I agree that this is a very nice thing. The procedure of your own is always better. A big advantage according to me.
And what happens is that in mechanisms where parties kind of know each other, so traders know each other, they've been dealing them since a long time due to course of trade, etc. So they essentially know, what is the meaning of each document and, import of this document, and they can decide that, we will decide the whole dispute only on purchase orders. We don't want any other evidence to be coming. Only purchase orders.
So the evidence also can be curtailed.
Evidence also can be curtailed in the way you want it, and curtailed, presented in one fashion. Whatever you want, can be decided as rules of evidence also.
So that is really flexible.
There is extreme flexibility. So the law essentially says that first chance is given to parties to decide the rules of the procedure. If parties decide the rules of the procedure, the arbitrator follows those rules.
Right.
So you can literally design your own CPC and your own, part which regulates the trial part of the procedure in your own, and also the evidence part of it. But if the parties don't decide, the option is given to the arbitrators then to decide whichever way they think is the word is appropriate. in the section, then whatever they think appropriate. So now then people say arbitrators are deciding on their own, but the first choice was given to the parties to decide this. But parties usually it's burdensome to design a set of rules and all that, and hence don't do it. And that's why this again goes back to the institutional arbitration, that institutions give you the main thing that they give you is a set of ready-made rules, how to conduct arbitration. And they oversee those rules, that they are followed or not.
So this is an advantage
With the institutional arbitration. But in ad-hoc also, I have seen a number of arbitrations where extremely convenient procedures are designed by the parties in agreement with the tribunal, that this is the procedure we want to follow and not the regular. Because the downside of it is, and you asked about procedure, Rishikesh, is so important. The downside of it is that we can tend to fall back on the evidence in CPC principles, if not the actual text of the sections. And the classic example of this is proof of documents. Contents of documents. Our mechanism of, so it's not actually proving documents, it is the proof of contents of documents.
Now another thing is, how is the court fee decided? Like, is there any court fee for arbitration?
So this is an interesting aspect. The fee is decided by, like the rules of the High Court. So the mechanism is, there is a power under section 11 for the High Courts to frame rules regarding the fees to be payable to the arbitrators. Some High Courts have formed those rules, some have not formed those rules. I mean, that's the situation as stated. For example, Bombay High Court has 2018 rules to pay the arbitrators, and those rules essentially follow what is scheduled for scheduled to the Act timing, where a scale schedule is given of what fees to be paid to the arbitrator. But this is ad valorem, as we say in court fee language, where it is based on the size of the claim and the counterclaim. So claim and counterclaim are considered together.
So the percentage is already given.
Like how much money is to be paid, and it is slab wise. If your claim is from this size to this side, then this much is the fee. Then so it gives you a minimum number, and then a multiplier is given for the amount which is above that floor amount. So I mean, it's there in the Act. So I
can put. And then like we file pleadings.
Yes.
Before the courts.
Yes.
What is the procedure? Like, how do you file pleadings before arbitration?
Correct. So the European style of the arbitration, which can be adopted here, there is no problem about it. And in international arbitrations, it's quite popular, is known as memorial style of the pleadings. So memorial style of this, it comes from the civil law. Memorial style of the pleadings means presenting all your evidence in one go. I mean, along with your pleadings. So that is one memorial of all in one. I think that style is more suitable for arbitrations. So can be done, but because most of our practitioners and arbitrators also come from the civil litigation background, we have this system which is notice pleading kind of system, where first pleadings are put in, so we attach some documents, exhibits to it, then we have list of documents being produced, then we have like affidavits of evidence being produced and documents annexed to that affidavits of evidence, then the witnesses also produce compilations or documents, then finally more documents are produced to confront the witness because our general litigation allows it. I mean, so these 4 avenues to produce documents, which also is the reason why civil litigation is so slow. I mean, for
arbitration is advantageous.
So that culture has been brought in here, and because procedure is flexible, they say that adopt the same thing which we are familiar with.
That's right.
So somehow when they say that if that is not done, then due process has not been followed. I mean, but because the procedure is flexible and parties can decide, so people sometimes say that arbitration is as expensive as litigation. This is one charge which is laid against the arbitration. But if you follow the same procedure which is in litigation, it's bound to be same time would be consumed and same this thing would be
true.
So best thing are the memorial style pleadings, where everything, all the evidence that you want to produce, documentary evidence I'm saying, should be there with the pleadings itself.
Right. Now coming back to the agreement aspect, you had mentioned that parties have to agree either in contract or afterwards
also.
So what are the nuances of agreement when it is essentially in form of written contract?
Yes. So what the standard mechanism is to adopt a model clause. So if you pick up any bare act of like the Arbitration Act, I mean, a model clause is given at the end.
Okay.
And like that can be adopted as the clause for arbitration in a contract that you are writing. But somehow it has become an interesting phenomena that people reinvent the arbitration clause in the sense that they put very colorful clauses, and there is a particular phrase which is used in arbitration literature. These are known as pathological clauses. So they come with like disease built into it. So I'll give you like a classic example of it. Is parties putting language in the arbitration clause that if the parties decide, they may go into arbitration. So now when this is brought to the court, when the parties don't, one side gives notice, the other side doesn't agree in the court, the courts will say this is may, which is optional. Uncertain. So you may arbitrate, you may not arbitrate, and now we are not agreeing to arbitrate. So how can we send you to arbitration? And courts have to follow what the parties have agreed to in the agreement. So these are pathological clauses. There is no need to introduce them. They add zero value to it. Whether you want to choose ad hoc or institutional, go with the standard model clause. So apart from the rules, the institutions also provide you a model clause on their websites. Just adopt their model clause. Don't reinvent the wheel. I mean, if you want to go with institution, if you want to go ad hoc, the books provide you model clauses. Just adopt that, which is simply saying that you will follow the procedure which is given under the act. That's all it is in the ad hoc arbitration.
So what will that clause essentially contain apart from agreement between the jurisdiction?
The jurisdiction is mainly in this thing. What the clause covers is the scope of the arbitration. What disputes would be submitted. So parties, for example, traders may have 10 disputes underlying it. So whether the immediate dispute they want to submit to arbitration, or all the pending disputes they want to submit to single arbitration, or all the disputes in one single year. I mean 2023 for example, what needs to be submitted to the arbitration needs to be detailed there. So either it is under some main contract, and also one contract can give rise to 10 disputes.
True.
So in construction dispute there can be different stages at which different disputes have arisen. So there is no order to rule to kind of mechanism here that all the disputes should be there in one plane. I mean as such. So or you have to take leave of the court result. That mechanism is not there. So the scoping is given here, this thing, and usually it is there that one contract and anything which has risen under that contract or related to that contract or touching that contract, I mean that will be resolved by this dispute, because ultimately you don't want this res judicata and stay of suit mechanisms which are there in civil litigation to be brought in here. Those are not suitable for this mechanism.
And since you just mentioned this civil litigation, for our audience, let this also be clear that arbitration is only for civil litigation.
Yes, this is only for civil dispute, not for criminal litigation. So don't try that.
Yes, so that is also one of the important
points. Correct. There, I mean, you have please arguing other things which are, but that's not in the domain.
So therefore, now we will also understand the jurisdiction, since you have already mentioned what can be arbitrated. But how does the jurisdiction, as in the place where the arbitration has to be conducted?
So there is this mechanism of the seat of the arbitration. So the arbitration law has two concepts, which is the governing law of the contract and governing law of the arbitration agreement itself. So although the clause is in the same contract, these two laws are technically different. I mean, so our law and ancestral model also uses the word place. It does not use the word seat, but place and seat mean the same thing. Okay. Our courts have decided, because people started, some agreements have place, some agreements have seat. So the courts finally decided that place means seat. I mean,
so even like Supreme Court has also
settled that place means seat. And courts also in the judgments use the word seat, but technically the word is place of the arbitration as such. So that's where the law which will apply to interpreting the contract, that law is known as the governing law of the contract, and the seat law, also called lex arbitrability, I mean, is essentially the law which governs the procedure of the arbitration.
And would there be any limitation period?
The limitation law applies to arbitration. No difficulty. I mean. So there is a special provision here which says limitation that in case if your arbitration fails, you can restart it. The limitation is
Okay.
safe.
Now this is a different thing.
Different thing, I mean, as such, because it's a consensual mechanism and it could fail sometimes. So then people should not be left remediless. So that's why that mechanism is given. But I think it's too technical to get into that.
Okay. So let's take a break for a while,
Yes.
and then we will get into another part.
Sure.
At least we have got the brief idea of the basics of arbitration. So now we will get into the subject in more detail in the next part.